Is it possible for your 21-year-old US citizen child to help you get a waiver and a green card? My name's Erick Widman. I'm an immigration lawyer, and a very common question we get is for our undocumented clients and potential clients. They're wondering, they've heard that their 21-year-old US citizen child can now petition for them to help them get a green card, and sometimes they know they probably need a waiver. And a waiver is required when someone has unlawful presence from overstaying a visa or from entering illegally into the US and not having valid status here. So a common question is it possible if someone needs this unlawful presence waiver for the 21-year-old or above US citizen child to petition for the undocumented parent? So what's tricky is that, yes, it is possible for the child who's over 21 to petition for a parent, to file the form I-130, and even to get it approved. The US immigration system is so confusing and so treacherous that many people will think, oh, my child's I-130 was approved, I'm on my way to getting a green card. And even if they understand what an I-601A waiver requires, they often miss the key element, the second element that's essential for this process, and that is showing extreme hardship to a qualifying relative. But whoever is a qualifying relative can be confusing. We need to pin down exactly who can be a qualifying relative and show extreme hardship to that qualifying relative, and who is just not possible to show that for. So who can be a qualifying relative? Under US law, a spouse or a parent can be a qualifying relative. So it's really tricky for undocumented parents who have a 21-year-old US citizen child now, is that child can be the petitioner but cannot be the qualifying relative, and it just doesn't qualify, it doesn't work to show extreme hardship to your US citizen child. They are not a qualifying relative, and many applicants can get hung up on this issue. So here's a couple examples. If you are undocumented and you marry a US citizen spouse, or your spouse has a green card, your US citizen spouse, LPR spouse, can petition for you with Form I-130, and your US citizen spouse or green card holder spouse can also be the qualifying relative. So you could show extreme hardship if you had to leave the US and return to your original home country. If you show extreme hardship to your spouse in that instance, that works. That person can be a qualifying relative. But your child could petition for you in another example, but you would need a different qualifying relative to show extreme hardship to. So what could work, and what is often difficult, and the scenario is challenging, you could have a child who's a US citizen petition for you, but you would need to show extreme hardship to a spouse or to your parent. So and that's when the situation gets more and more narrow. It's not that common to already have, if you're undocumented, a parent who is a US citizen or has a green card, because your parent can be a qualifying relative or your spouse could be a qualifying relative. But you might as well have, in those situations, your parent or your spouse petition for you directly. Therefore, this is all quite confusing, but the key thing to remember is that yes, your child can petition for you, but cannot be a qualifying relative. Hopefully that is helpful. There are some other bright spots in US immigration. Unfortunately, this is not a very promising and uplifting topic, because usually when someone comes to us with their optimistic hope that their 21-year-old child can now help them out, it doesn't help with the I-601A waiver in most cases. But it does definitely help if you overstayed your visa. If you're an undocumented parent who entered with inspection, your child in that instance can petition for you, and you don't need an unlawful presence waiver that will require you to leave the country. Lots of interesting details to explore further. We're going to end this video here. Let us know if you have any questions, and take care.